Hey everybody, we got folks coming in.
Willie, I was able to add Andrew as a panelist internally. So, Andrew, can you just test your mic real quick and make sure we can hear you?
One, two, testing, testing.
Perfect.
Hey, Tyler.
Cool. Thanks everybody for joining. I'm looking through the participant list. I'm seeing a lot of names I know. Um, Mike, Tony, welcome. Please regard this all as not as off the record, not for reporting. But you're welcome to be here. Any other journalists, this is not none of this is for reporting on. But feel free to reach out to me to talk about, the story. But this webinar is really it's for an organizing space. All right. Well, let me go ahead and open my slides and share my screen, and we'll get started. Everybody can see that. Let me minimize this. All right. I'm Willie Dotson. I'm so glad y'all are with us today. I'm the Coal Impacts Program Manager at Appalachian Voices, and I'm joined by Rance Garrison, one of our communications team members, who's running tech for the webinar, as well as Andrew Young with Allegheny Blue Ridge Alliance. He's the staff attorney there, and I'm going to pitch to him a little bit later for a portion of this. I am risking doing this outside on my porch just because it's so nice out here. So if I hope the sound is okay. If the sound of passing cars or birds or anything is distracting, then Rance or Andrew text me so that I can see it because I've got the chat closed. So we're here today to talk about the mining that is happening in Greenbrier County, West Virginia, within the proclamation boundary of the Monongahela National Forest, and right on the edge of the Monongahela. This is there's a unique threat to our public land right now, that is exemplified by these mines, and what South Fork Coal Company is getting away with in terms of hauling coal through the national forest right now, um, and discharging pollution into the Cherry River, which is part of the Gauley River watershed. And of course, the Gauley River National Recreation Area is another major public land in West Virginia. So these operations are impacting public lands in a number of ways. Another a unique element of the threat, as we see it, that we'll get into a little bit later, has to do with some of the executive orders and maneuvers to utilize emergency powers that we're seeing out of the Trump administration. But we'll get into all of that in due time. So the photo you see there to the left is a pristine tributary to the Cranberry River. The photo to the right is a once pristine tributary to the Cherry River. These are maybe 10 miles apart from one another. They're very close. They're both headwaters to the Gauley River. They're both beautiful, as you can see, and we juxtapose these two next to one another to demonstrate that the photo on the left enjoys the protections of being public land. The photo on the right is just outside the Monongahela boundary, so has not traditionally enjoyed those protections. The one on the right is a creek called Becky Run, that has a lot of water quality violations coming off of South Fork Coal Company mines, impacting it. And we're concerned now that the threat is broader, and that even public lands and public waters are kind of on the table now for the coal industry and for this administration. Let's see, how do we do that? Oh, is this going to work for me? Gonna show a brief video that Highlands Conservancy put together earlier this year.
The Cherry, Cranberry, and Williams Rivers carve through
Willie, the sound on your video went out just now.
What was that, Rance?
Uh, folks can't hear the video that you're trying to play.
Oh shoot. Okay, well we're just gonna have to roll past that. Um, this video is
I think it's maybe the video looks like it might be muted on your side of the screen.
well, I just now muted it after you.
Okay, gotcha.
Yeah. Um, yeah, we're just gonna have to roll past that. How do I make it go away? There we go. So this was a video that West Virginia Rivers made uh, earlier this year for part of the endangered rivers announcement. American Rivers determined that the Gauley River is the 10th most endangered river in the country for their designations of endangered rivers this year on account of these mines. And this video is just a good summation of the issues, but we're going to just have to roll past it. So the photo you see here is the Rocky Run surface mine. This is in Greenbrier County. It's about maybe 30 miles north of Lewisburg. Um, and it's much closer to the town of Richwood in Nicholas County. It's part of a complex of mines uh, of 3,600 acres that surround the South Fork of the Cherry River. There's also a haul road involved with this complex that crosses over into Pocahontas County a little bit and impacts the North Fork of the Cherry River. And there's also a prep plant as part of this complex that is on Clear Creek of, believe it's the Meadow River over there. Um, the haul road at question here is called Haul Road number 2. It trucks coal from the Rocky Run surface mine through the Monongahela National Forest to reach the prep plant. Over the past, by averaging out the tonnage produced by the Rocky Run surface mine over the past several years that it's been operational, we average out that there's about 100,000 tons of coal per year that has gone through the mon. That is not lawful, which we'll describe in a little bit more detail later. Um, and in addition to using private roads through the Mon, Haul Road number 2 also overlaps with Forest Service roads themselves. So public roads that you or I can also drive on because they are Forest Service roads are also being used to haul coal through the Monongahela. South Fork Coal Company, it's fair to say, is a bad actor in the area. Since 2020, we're aware of 141 DEP enforcement actions. Andrew told me just a couple days ago that there was another batch of violations issued in May that I haven't looked into yet, but it looks like there's sediment issues and reclamation issues uh, uh, more recently cited as well. We also found 82 self-reported Clean Water Act violations on the discharge monitoring reports that coal companies keep for themselves for this company since 2019 that had been submitted to the DEP, and the DEP had not taken any enforcement action on them. Some of these violations, many were for sediment, others were for various metals. Some of these metal discharges were literally 900% above legal limits. So that gives you an idea of the impacts of this company on the water quality in the South Fork Cherry River where it operates. On this map here, you can see this is the Rocky Run surface mine. Kind of goes like that. I think it's 11 or 1,200 acres. Huge mine for a contour mine. Usually when you see that kind of acreage, it's a mountaintop removal mine. It's just a whole peak, a whole area, valley fills. This is a huge sprawling contour mine. This is the Monongahela over here in green. This little bit of purple that you see is haul road number 2. So coal gets trucked off of Rocky Run surface mine onto the Forest Service roads over here. and then onto Haul Road number 2, and then it takes this long circuitous route over to the prep plant, which is a little off screen here. These are some other mines, these yellow ones that are all run by South Fork Coal Company, and all of these blue and black dots on the screen here are the site of water discharges and violations. So little bit of kind of 101 stuff here. I know I recognize a lot of y'all's names, and I know a lot of y'all know this stuff already, but the Surface Mining Control and Reclamation Act is the federal law that governs surface mining in the United States. It was passed in 1977. It established a federal coal mine permitting system and various environmental controls applicable to coal mining, various assurances that reclamation would happen. And one thing that is in the Surface Mining Control and Reclamation Act is a ban on coal mining in the national forest, with some exceptions. It's not a 100% ban, but those exceptions are fairly narrow. For our purposes here, I want to talk about some of the relevant players. The West Virginia DEP regulates coal mines in the state of West Virginia. The way SMCRA works, the Surface Mining Control and Reclamation Act, is a federalism system, which is to say that states are the primary actors who issue permits to coal mining operations, inspect those operations, issue enforcement actions, and so on. That's true for most states. There's some exceptions to that nationally. In West Virginia, the Department of Environmental Protection is the primary regulator with authority over these mines. The OSMRE, the Office of Surface Mining Reclamation and Enforcement, does retain oversight over DEP and other states' implementations of SMCRA. So there are processes, even though DEP has issued the permits in question here, there are processes by which we can appeal to OSMRE to regulate matters when we're not satisfied with DEP's actions. The Fish and Wildlife Service enforces the Endangered Species Act relevant to coal mines and everything else. And the DEP or any state permitting authority must consult with Fish and Wildlife Service when a mining permit application is in an area that endangered species are known to be present or may be present. And then Fish and Wildlife Service has discretion to sign off or not sign off on that mining permit. Generally, what happens is they're going to say, well, this can proceed, but you have to put some protective measures in place. You have to do this that way. You can't do that, et cetera. And if you promise that you'll abide by those protective measures for the endangered species that are present in that area, then we'll sign off on your mining permit. In this case, the Forest Service is a relevant player, not usually the case for mines in Appalachia, because you're not allowed to operate a coal mine in the national forest. But in this case, it is relevant because of Haul Road number 2. So the Forest Service, of course, manages the MON. And in the case of a company wanting to use Forest Service roads to haul coal or to bring equipment in and out from an operation, similar to the Forest Service, to the way DEP works with Fish and Wildlife Service, the coal company would have to go to the Forest Service specifically and ask for authorization to use those roads. And of course, the final relevant player here is South Fork Coal Company. South Fork Coal Company is based in Richmond, Virginia. As far as we can tell from the research we've done so far, a lot of the financiers and the money behind this is tied up in the stock exchange in Toronto. It's Canadian money behind this company. And then these are the relevant players on our side of things. West Virginia Highlands Conservancy, Allegheny Blue Ridge Alliance, and Appalachian Voices have been kind of the key partners that have been working really closely on monitoring this company and pushing back against their abuses of the public land and the water for the past few years, and all of these other organizations have been party to it in one way or another. Center for Biological Diversity and Appalachian Mountain Advocates have both provided legal counsel, and all of these other organizations have either signed on to lawsuits or signed on to complaints or worked with us in some capacity or another. So we're developing a campaign here. We're a couple years in that has three main arms to it. The first two more developed than the third. So lawsuits and administrative interventions. We have sued the Forest Service for allowing use of the roads. We have sued the company for all of those self-reported Clean Water Act violations, as well as for some SMACRA violations. And we have used administrative complaint systems through the OSMRE to, for a short time, get the Hall Road shut down. And I'll go into a little bit more detail about those in a minute here. We regularly review public enforcement and permitting documents. Mostly Andrew Young from ABRA is doing that. The DEP, to their credit, have fairly easy to navigate public information systems online. So we are able to check inspection reports. We're able to check violation reports. We're able to look at the coal permits themselves, which are complex documents with a lot of different attachments. We've also gone and done physical water monitoring in the Cherry River below this mine. And because of the position of the mine kind of on the edge of the National Forest and the Public Forest Service roads kind of up above it, as well as the Fork Mountain Trail, there's a hiking trail that's like right next to the mine. There are also public vantage points where we can fairly easily look at the road and somewhat put eyes on the mines themselves. Now, this third arm that we're kind of trying to cook up right now would be more of a kind of can we build a mass movement here? Are there enough people who are concerned about this, either because they're local to the area or because they're invested in the survival of the Monongahela National Forest in in its pristine form and for all its wonderful uses for our recreation and our spiritual renewal and the economics of West Virginia. Do we have enough traction with people to actually build a protest movement of some sort against these operations and in protection of the Monongahela, the Cherry River, the Gauley River watershed? So South Fork Coal Company came into existence in the 20-teens and acquired some mines that already existed that were permitted to other companies that have transferred to South Fork Coal Company and began, opening new mines as well. In 2018, the North and South Fork of the Cherry River, as well as a few other areas, were designated as critical habitat for the candy darter and endangered small fish that exist only in certain parts of the New and Kanawha River watersheds and that has lost most of its original habitat. In 2022, Allegheny Blue Ridge Alliance launched a conservation hub site disseminating info about the impacts of South Fork Coal Company's mining on the candy darter habitat. And I just wanted to show y'all that for a moment here. These conservation hub sites are resources that ABRA puts together, demonstrating the kind of what's ecologically special and unique about different places that are threatened by some sort of industrial activity or infrastructural activity or other. And them taking the initiative to put this together for the Candy Darter and the Cherry River. Also, it's worth noting that there's high elevation red spruce forest here, and as far as we are aware, these are the highest elevation mines in the state of West Virginia. And to operate these surface mines necessitates the clear cutting of red spruce forest, which is a very rare and special environment, particularly as far south as we are. That's, you get into like a Canadian type forest at some of these elevations up around 4,000 feet in the Allegheny Highlands, and these mines are in that sort of area. So ABRA putting this site together was a major catalyst to App Voices, kind of starting to work with them on addressing the problems caused by these mines. So the Conservation Hub site includes, if it'll load, the map that we were looking at earlier. You can click on any of these and get more information about what's the violation that happened there, et cetera, et cetera. Can move around. It's just a great resource. I encourage everybody to look it up. I'll be happy to share these slides when we're done, and you have the link in the slide. So in 2023 is when ABRA, Highlands Conservancy, and App Voices really began working together in earnest on these mines. At that time, I think it was February of 2023, one of the permits in that area, I don't remember which one, had applied for a modification to expand by 30 some acres and put in a couple new discharge points. And so the kind of first way we got involved as a coalition working on this was to examine that modification, examine the past history of the company, conclude that they have not allowed themselves to be bound by the terms of their permits up to this point. So why would we allow them, to expand the permit? So we opposed it. DEP issued the modification, despite the evidence that we brought that the company was not doing a good job with its existing permits. In January 24, we stepped up our campaign by filing a lawsuit against the U.S. Forest Service, represented by the Center for Biological Diversity. And the candy darter was key to this. The Forest Service had granted South Fork Coal authorization to use Forest Service roads, both to haul coal and to bring equipment in and out of Rocky Run Surface Mine, without having done the necessary Endangered Species Act consultation with Fish and Wildlife Service, and without having conducted any sort of NEPA review. So our complaint was that the Forest Service granted this authorization arbitrarily and capriciously because they didn't follow the proper process. And our request, what we were asking from the court, was make sure the Forest Service does those environmental reviews. They are non-discretionary. You must do them. And in the meanwhile, they need to withdraw their road use authorization. We need to shut down this haul road. So that was the lawsuit we brought against Forest Service in 2024. In January that year, we'll come back around to that. A little later that year, in June, Andrew at ABRA submitted a complaint to Office of Surface Mining detailing the fact that haul road number 2 was operational in the National Forest without the company having ever demonstrated that it qualifies to do that, because there's kind of this default ban on operating within the National Forest. And there are exceptions, but there's a process to demonstrate that you qualify for one of those exceptions, which South Fork Coal had not done. Importantly, we found that in their permit applications to the DEP, South Fork Coal even checked a box claiming that the haul road did not even go into the National Forest, when it clearly does. You can look at a map and see that it does. And if it didn't go in the National Forest, why would the coal company have requested that the Forest Service grant road use authorization within the National Forest in the first place? Later last year in December, we filed another lawsuit. The first one was quite a few parties. The second one was just Highlands and App Voices. And we're represented by Appalachian Mountain Advocates out of Lewisburg on this one, against South Fork directly for all of those Clean Water Act violations that we discussed earlier. Quite a few were 100% the legal limit. A few went up to 800 or 900% the legal limit. And there was also some reclamation violations that are under SMACRA rather than the Clean Water Act that were included in that complaint. So the relief we sought there was obvious. It's just stop doing that. It's just obey your permit, clean up the existing violations, and stop polluting the water. Also in December, 11 organizations sent a letter to the then head of the OSMRE, a woman named Sharon Bacino, following up on the complaint Andrew had sent back in June, just saying, hey, this company continues to operate a haul road in the national forest. They have not demonstrated that they qualify for an exception to the ban on that, which is a thing called valid existing rights, which we'll get into here in a minute. And Sharon Bacino, we need you to shut down this road. So I'm going to pitch it to Andrew for a second. Are you able to come off mute, Andrew, and talk to us about valid existing rights?
Yeah. So functionally, there is a blanket prohibition on surface mining operations and impacts within federal lands. And I don't want to get too wonky here, so if anyone has questions, please follow up separately. And I'm happy to go in depth and bore you. But functionally, this is in 1977 when the Surface Mining Control and Reclamation Act was passed. It included this ban on surface mining operations and impacts in national forests in the east, short of two very narrow exemptions. One is if it's incident to a deep mine and the Secretary of the Interior makes a determination that deep mining is not incompatible with land and resources. But the other option is, which is not a question here, that's not really an issue here. We're dealing with a surface mine. The issue here is valid existing rights, which the way this is supposed to go is before 1977, a company invested in an area to develop it for coal mining, et cetera. The foundational approach to this is that an entity, either a person or a company, has a right and relied upon pre-SMACRA status quo to make investments in the land in order to develop it to get the coal out. And so there's three pretty clear, straightforward ways to get valid existing rights. And then there's another set of circumstances that came about in 1999 that are dealing specifically with a haul road. So as you can read there, the company or the person had necessary authorizations prior to the land becoming coming under the protections of 522E is the language. So there's the good faith efforts, and then they request and obtain a favorable VER determination from OSMRE. So all of this is supposed to happen prior to mining operations commencing. And I don't know if it's obvious yet, but South Fork Coal did not have any of this when in 2013 they submitted their first permit for the haul road. They submitted it to the DEP and they said on their map that none of this permit boundary goes within or adjacent to any national forest, national parks, etc. So there's a timing issue here. There's a sequencing issue where this is essentially turned into a after the fact approval of something that's supposed to be prohibited short of a very narrow exemption. Willie, what else do you want me to cover on this before?
Well, let me jump in for a second, and then I'll pop it back to you to kind of talk about the nuance of the haul road VER issue. But yeah, as Andrew said, they did not demonstrate property authorization or the necessary permits that had existed prior to the area becoming protected by the national forest. And they had not taken the initiative to bring any of that information to OSMRE and request a VER determination at all. The only thing that prompted them to ultimately do that is what I was just talking about. It was the complaint that Andrew sent in June and the follow-up letter that 11, West Virginia or regional-based organizations sent in December, at which point South Fork Coal Company was then compelled by OSMRE to request a VER determination. So they did not do that in advance either. The standard for proving valid existing rights is a little bit looser. Maybe that's not the right way of putting it, so Andrew, correct me, but it's a little bit different for a haul road. as opposed to the mine. Now, there's an argument that the Rocky Run surface mine is impacting the Monongahela National Forest. I think that's an easy argument to make, but the haul road itself crosses through the national forest, so that's what we're talking about here. So let me pass it back to you, Andrew, to talk about how VER works for putting a haul road in the national forest.
Yep. So there's three main criteria to the haul road, and this is from the 1999 OSMRE VER supplement, which actually came about, without boring you too much. The new regs for VER determinations came about in part because of prior VER determinations in the Monongahela, as well as in the Daniel Boone. Those have been the two main ones, as far as I can tell from my FOIA requests. But I think it's worth mentioning here that this is the first and only time that I have been able to find in, I guess now it's almost 4,000 pages of FOIA responsive documents on valid existing rights requests where it has happened in this manner. Every single other time that that's documented, the company or the individual has gone to OSM and the Forest Service before commencing operations, to go through this process. And there are other rejected valid existing rights determinations in the Monongahela and in the general vicinity of this operation, which I don't want to get into any allegations or anything, but I find it incredibly conspicuous and red flag as to why in 2013 the company submitted the misrepresentation that it didn't go through the national forest. I think that we all could probably come up with some ideas as to strategically why that may have been a decision. But here, A is the most important reason, and that's the one that the company is citing. They're saying that the road existed when it came under protections, so in 1977, and that they have the legal right to use that road for surface coal mining operations. So that means, essentially, functionally, their argument here is that the road existed, and that their permit, which they obtained in 2021 from the Forest Service, like retroactively for this haul road, that grants a legal right. And they cite Daniel Boone determination that says that a Forest Service special use permit and the fact that the road existed is sufficient to satisfy that criteria. So that's probably their strongest argument. And the way that we broke that down was, first of all, the road use permit is regardless of whether or not this road existed, like we don't see that point, and you should prove it though, which they don't seem to have necessarily done. But the road use permit is invalid and essentially void, insufficient, and therefore falls far short of this valid existing right, the standard, which is a legal right requirement. And again, this is an exceptionally high bar for an extremely narrow window to a blanket prohibition. And our argument against using the road use permit to satisfy a legitimate right is that there was no NEPA or ESA compliance, and that was granted arbitrary and capriciously, which obviously I think we'd win on, but we'll see what happens with that case, and that it's subject to ongoing legal challenge. So the permit's legality is actively disputed in federal courts on the grounds that it was unlawfully issued, and that a permit mired in litigation cannot qualify as a legal right. The other argument, which amazingly the Forest Service admitted to us, that the permit is flawed and needs to be redone. So they've started doing a NEPA process and ESA consultation for the haul road use of Forest Road 249. Essentially, the fact that it needs to be redone means that the current permit that they're citing is not a legal right. And the last part of that arm that we took umbrage with was that in 1990, because the Forest Service and OSM were getting so overwhelmed with VER requests, they established a memorandum of understanding that set about a number of procedures that the agencies would go through to coordinate on valid existing rights claims in national forests in the East, before approving activities like a haul road. And that essentially here, no such coordination happened whatsoever, and that the process has fundamentally broken down, sufficient that that first prong can't be satisfied. So the other ones are less substantive, but they still are at play. The second prong of that that you can satisfy is no pre-SMACRA recorded right-of-way or easement. And so South Fork here says that they cite a 1934 deed from the Cherry River Boom and Lumber Company that took out a general reservation of access to get the minerals out of the land. And so South Fork says, oh, that general reservation of rights is sufficient to satisfy the valid existing right standard. When in reality, that goes against OSMRE and the Forest Service's interpretation of what the deeds, what was reserved under that deed. There's numerous past valid existing rights determinations that rejected relying on that deed because surface mining wasn't contemplated in 1934 when the deed was originally when it was originally authorized. The last thing that I would say to this is that that deed does not establish any easement whatsoever specifically, and that OSMRE's rules require that surface mining was explicitly reserved as a right under the deed language. And obviously, since it wasn't contemplated or a practiced thing, it was never recorded. And that the other things worth mentioning is that there was never a specifically recorded roadway easement in that deed. And moreover, South Fork Coal Company can't cite, and they never did in any of their permit applications, a mention of a recorded right-of-way under that deed. Instead, they also omitted all references to federal ownership crossing. So basically, they denied that the haul road entered the National Forest land at all. Which it's strange that if South Fork truly believed a specific haul road right was reserved in 1934, it would have disclosed that in their surface mining permit application. The other thing that undercuts their claim of a valid easement under that deed is that they even had to apply for a Forest Service special use permit at all, because a properly recorded easement would have entitled them to occupy the surface there. So, and that also gets to the lack of pre-1977 rights, which goes to the other prongs. So, and I'll stop talking here now. But functionally, they fail on all of those points, and we have detailed comments if anyone's interested in reading organizational comments that approach and sort of deconstruct all of these. So,
thanks, Andrew. Yeah, there's a lot of information here, and we could not have mounted the campaign we have thus far without Andrew's diligence and legal expertise here. So yeah, if folks have questions, which I imagine you may, because this is very dense, we'll save some time for that at the end. I'm also going to give everybody my email, Andrew's email, and Olivia Miller's email with West Virginia Highlands, and people can follow up with this. We want you to follow up with us. We want you to get involved. We need more people working on this with us. So I want to come back to the timeline. In January of 2025, it was indicated to us that the Forest Service, in so many words, it was a bunch of legal dodgery, but was conceding that NEPA and ESA reviews had not happened and that they now would, but they did not agree to shut down the haul road in the meanwhile. And this speaks to what Andrew was just saying. The South Fork Coal cannot rely on the road use authorization to justify their the legality of their haul road when that road use authorization was granted improperly, and by now commencing NEPA and ESA reviews, Forest Service is essentially admitting that it was conducted improperly. Also in January of this year, in response to ABRA's complaint and the December follow-up letter by 11 organizations, Sharon Bacino, then director of OSMRE, I want to say her name because I want to give her credit, shut that road down. Okay. And that was a big win, and I have a lot of gratitude to her for that. She looked at the information we gave, she looked at the law, and she did the right thing. She issued a cessation order saying this road has to be shut down while all this valid existing right stuff is worked out. Unfortunately, things start to get bad. We had a couple wins in January, and then things started getting bad again. So in February, South Fork Coal appealed that closure order that Sharon Bacino had issued to an entity within the Department of the Interior, called the Office on Hearings and Appeals, who then lifted the closure order and reopened Haul Road number 2. There's some real problems with this, namely that we were not notified of that proceeding at all. And the closure of Haul Road number 2 was based on information brought by Allegheny Blue Ridge Alliance and then bolstered by all these other organizations. So we should have been considered party to these proceedings and invited to weigh in, and we were not. Also in February, South Fork Coal declared bankruptcy. That paused our litigation. Okay. When an entity is in bankruptcy, if you have any dealings with that entity that could extract finances from them or impact their estate, then the fact that they're in bankruptcy imposes an automatic stay against those proceedings. So the bankruptcy of South Fork Coal puts a stay on our litigation against them. That means we do not have any power right now to enforce those 82 Clean Water Act violations through litigation. DEP still has the power to do it. They're the regulator. The bankruptcy doesn't affect them. It's called a police powers exception to the stay that's imposed by a bankruptcy. This also paused our litigation against the Forest Service, which we don't think is fair and proper. Because our complaint in that case is against the Forest Service for not following their own procedures properly in granting that road use authorization. Whether South Fork Coal gets to use that road or not, it's not part of their estate. It doesn't have to do with them. It's just Forest Service needs to follow their own processes. So we have obtained additional legal counsel who are working with the legal counsel we already have. This additional legal counsel is in the state of Delaware, where the bankruptcy is unfolding, and we're working with them to bring these issues to the judge and request clarity that the stay does not, in fact, apply to our litigation against the Forest Service, so that we can hopefully proceed with that one, and also provide some clarity from the bankruptcy judge as to our capacity to enter into the DOI's Office on Hearings and Appeals and make some objections there to the way that Haul Road number 2 was reopened without allowing us to come into play. So we're still working on it. We'll see how those things play out. Okay, I want to pivot. I'm going to try to get through this stuff in maybe 7 minutes or something, and then leave the last little bit for questions. I was going to try to keep this to an hour. I can be here a little bit longer if other folks want to, and if that's cool with Rance, who has to run the tech for this. So Trump has issued some executive orders that are quite alarming. On Inauguration Day, Trump issued an executive order that declared a national energy emergency. It claimed that our energy production is inadequate. It did not present actual, evidence to support this, and it is a false claim. The United States produces more energy than it has at any point. It produces more energy per capita than almost any country on the planet, except for a few countries that have somewhat small populations and very large, reserves of oil and stuff like that. We produce more energy per capita than China, more energy per capita than Russia. There is no energy emergency. He declared an emergency because in a state of emergency, the executive branch has access to various emergency powers that allow it to circumvent regular checks and balances and due process. That's what the purpose of this is. The declaration of energy emergency invoked national security, and it directed agencies to use these various emergency powers. Also, on Inauguration Day, he issued an EO, an executive order, called the Unleashing American Energy something or other, which explicitly encouraged energy production on federal lands and broadly directed agencies to suspend, revise, or rescind regulations on energy production, except for renewable energy. It's baffling. Like a pretty short time ago, the common refrain you were getting from Republicans and Democrats alike was an all of the above energy strategy. But this administration is attacking renewable energy, which, to say nothing of the environment, is like a burgeoning, growing industry. So it's very economically stupid to try to stamp this out, and there's no reason for it except for fealty to dirty fossil fuel energy industries. Then in April, and there's other executive orders that are somewhat relevant to what we're talking about today, but these are the main three that I wanted to talk about. In April, there was another executive order called the something something reinvigorating beautiful clean coal something something executive order. It again invoked national security, and quite alarmingly, it declared coal leasing and related activities to be the primary land use for public lands with coal resources. So let that sink in. Basically, if it's federal land and there's coal there, then the management priority for that land is now the mining of coal. The experts and the kind of conventional wisdom on this is that it's really designed to try to open up and expedite a whole lot more coal mining on the federal land out west, but it is relevant to us as well for reasons that I hope are obvious in the course of this webinar. Invoking national security is particularly scary because of the emergency powers that a president and executive agencies can use in a situation where there is a legitimate national security emergency. In particular, the Defense Production Act and the Strategic and Critical Materials Act give the president really broad powers to manipulate private industry. Loans to private companies, subsidies, purchase guarantees, even commandeering private enterprises is at play here. I don't remember if it was this week or last week at this point, but there was a coal plant in Michigan that was set to go offline, and the Department of the Interior issued an order that it stay online for 90 days, or that it stay available for operation. So I'm not exactly sure what that means in terms of is it burning coal or not, but this that order cited, it didn't cite the Defense Production Act or the Strategic and Critical Materials Act. It cited some other emergency powers, but we are seeing the administration. I mean, this is a coal plant that's been there for a long time that is sunsetting because it is losing out in the marketplace to other energy sources. It hasn't even purchased coal, this particular coal plant, for like a year or two. It just was burning through its stockpile and sunsetting. And the Trump administration intervened and said, no, you can't close this coal plant because of an energy emergency. Okay, so these things that I'm kind of ringing the bell about, they're happening. Now let's talk about where is there coal in the national forest. This is a really wonderful map that was created by Matt Hepler, staff environmental scientist at Appalachian Voices, who is a very, very skilled expert on many things related to coal mining and GIS in particular, coal mine regulatory enforcement as well. So the gray on this map is coal. Okay, that's anywhere that there's coal. The green is the national forest, and this black line is the proclamation boundary. For anybody who doesn't know what that means, an act of Congress designates the proclamation boundary, and any land within the proclamation boundary, Congress has empowered the Forest Service, which is part of the Department of Agriculture, to make purchases and acquisitions and, to manage the forest. So what we're seeing here in green is current national forest. And the rest of this is the proclamation boundary. Yellow is anywhere that it is both national forest and a coal reserve. Okay. And this is a mineable, so-called mineable coal reserve. You can see over here, potentially mineable or other uses. There are other coal reserves. Subbituminous is very low quality. Lignite is very low quality that we're not including on this map. So this is anywhere that there's coal that is considered potentially mineable or to have some other use by the, I believe is the Office of Surface Mining's GIS layers we're using here. Much to the surprise, perhaps, of some Virginians, here's a big swath of coal right over here by Harrisonburg. I'm not too worried that this coal is going to be mined. I think it was mined a long time ago. I don't think it. I mean, regular market forces would not tend towards a coal company going into this area and mining this coal right now. These emergency powers are quite concerning. Andrew, let me get through this and then I'll bounce back to you. So here's the Wayne National Forest in southern Ohio, Daniel Boone National Forest in eastern Kentucky. I mean, as you can see, there's a lot of coal in eastern national forests. Much of Virginia is spared, but down here in Southwest Virginia, and then this little bit kind of in the Allegheny Mountains has coal in it. National Forest up north of Pittsburgh also full of coal. The area that we are talking about today is right here at the southern end of the Monongahela. Right here is where we're talking about, okay? South Fork Coal Company's mines are right in this area. Haul Road number 2 goes across the National Forest right in here. I just wanted to kind of shout out how awesome this particular area is briefly. I've been doing some form of this work for 20 years now. I've been an advocate and organizer around coal issues, and I'm very much motivated by the impacts to people, very much motivated by public health, by environmental justice. But I will say in this particular area, there's just a kind of conservation ethic that really motivates me here. This is an incredible area. The mines we're talking about are right here. You can see how close it is to Cranberry Wilderness, Cranberry Glades, Richwood, which is a cool little town that's a lot of people there are working really hard to kind of build a tourism economy there. Cranberry Glades, it's about 6 miles from the mines we're talking about. Falls of Hills Creek, second biggest waterfall in West Virginia, totally beautiful. It's about 3 miles from these mines. Fork Mountain Trail is a lesser known trail that literally goes right next to the mine. It crosses one of the Forest Service roads that is being used to bring equipment in and out of the mines. These pictures were taken from over near the Richwood end of this trail. This is like a 20-some mile trail that goes from roughly from Richwood to Hillsboro. Really cool area to have a trail on. And over on the Richwood area end of it, it's accessible too. Like that's a really special, rare resource to have a crushed gravel, fairly flat trail going up. This is the North Fork of the Cherry River that folks with disability issues, people in wheelchairs could like really get out into the wilderness. That's an amazing resource for the town of Richwood to have and to market for itself. The Cherry River, as we discussed, home to the Candy Darter, bunches of pristine trout streams, Eastern Hellbender, I mentioned the red spruce, and it's a tourism destination for fishing, for whitewater. The Cranberry Tri-Rivers Trail runs along the Cherry River, and all of this feeds into the Gauley, which is a major economic driver for southern West Virginia. So what can we do? I've talked a bit about how we're challenging permit applications and overseeing enforcement documents to keep abreast of things. We are opposing the VER determination for Haul Road number 2. One of the other mines that South Fork runs is up for a NIPDES reissuance. NIPDES is a Clean Water Act permit. We're going to be weighing in on that. We're going to have a water monitoring training near Charleston in September. I hope some of you will come. We're going to continue doing visual inspections and enforcement document review. We want to get the word out. Don't mind the Mon, hashtag don't mind the Mon. Please use that hashtag. If you go hiking in the Mon, take some awesome pictures, put them on social media, put don't mind the Mon. If you enjoy the Gauley and you want the water in the Gauley to be pristine, save Cherry River, hashtag save Cherry River, hashtag endanger Gauley. This is a link to a tool to help you write a letter to the editor and send it to your local paper. I'll not go there now, but I'll share these slides. And these are also links. This is linked to tell OSMRE not to grant valid existing rights determination. Shelley Moore Capito is somebody who understands the economic importance of tourism in West Virginia, somebody who I have a lot of disagreements with, but who I'm very hopeful